All right. Good day, everyone. And thank you for joining today's Ask Me Anything, where we answer your questions about cannabis legalization in New York. We do this every Wednesday at 4:20 p.m. New York City time. I'd like to welcome back those of you who have joined us before for previous Ask Me Anything sessions. And for those of you who are joining us for the first time, I hope you'll make it a regular occurrence. My name is Jeffrey Hoffman, and I am an attorney in New York whose legal practice focuses entirely on cannabis. If you would like to contact me, you can do that either here on LinkedIn. I welcome all connection requests, or at my email address, which you can see on the screen at the bottom, info@420jurist.com, which I guess you might say makes me the 420 jurist. And as the 420 jurist, I will be answering your questions, roughly half of them from a list of questions I've gotten from previous Ask Me Anything sessions, and roughly half of them from questions which you post in the comments here today. So if you'd like to ask a question, now is the time to do so. Give my usual disclaimer, and that is that I am an attorney, but I'm not your attorney, at least not yet. And therefore, today's event is not legal advice, does not create an attorney-client relationship, and is not a solicitation to offer legal advice. And so, with that, let's get to the questions. And the first question we're going to do is from a previous session. And that question is, can a person own a minority equity stake in 3 adult use retail dispensary licenses that each have a different majority shareholder? And although we don't have any specific guidance along the lines of that question, it does appear that the answer is indeed yes. So it is clear from the cannabis law that the most number of adult use retail dispensary licenses that any individual can have an interest in is 3. And there does not seem to be any guidance one way or the other saying that it's not allowed for you to be the minority stakeholder in 3 separate entities. So it does seem that indeed an individual would be able to be allowed to be a minority equity stakeholder in 3 adult use retail dispensaries. Now, that's it. They can't hold other licenses, can't hold any on-site consumption licenses, can't hold any cultivation licenses or any of the other upstream licenses. But it does seem that the law allows any person or any entity to have an economic interest in up to 3 adult use retail dispensaries. And there's no reason why you couldn't be the minority holder in each of those cases. So it does indeed seem that what the question asker is asking would indeed be allowed under our current paradigm for the ownership of adult use dispensaries in the state of New York. All right. Let's get some other questions. Here's a question from the session today. What are costs for attorney fee in cannabis application submission? Please advise. So, frankly, the attorney fee is going to be all over the map. Based on my initial take of what's going on with these conditional adult use retail dispensary licenses, this first license that's being issued, it's much more a forensic financial exam than a can you do cannabis business exam. There's no business plan requirement. There's no operating procedures. There's no security plan. There's no sustainability plan. There's not much of anything in this first application other than a forensic financial examination. And so what your attorney does with you is obviously advising you about the law, helping you fill out the application, although frankly, most of the things on the application. So like, give us all your bank accounts, give me all the stock holdings you have, et cetera, et cetera. The personal disclosure, which every true person of interest is going to have to fill out for this first application. Those are things that by and large, frankly, the applicant themselves are going to be in a much better position to answer than the attorney. I mean, basically, for the attorney to answer those things, it'll be basically, okay, you're going to pay me a bunch of money. Now, tell me the answer to all of these questions. So I encourage my applicants to do as much of that as they can. Again, depending on how much hand-holding you're going to do, my guess is this first license should not cost you more than low to mid to at the most high four figures. And that means I'm talking about thousands, like 4,000, 5,000, 6,000, 7,000. It depends again on how much hand holding you want from the attorney, how much of the application you can fill out yourself, or how many of the answers can you come to yourself versus what you will need your attorney's assistance with. I do, of course, recommend that you get your attorney's assistance in understanding all of the questions and making sure you got it. But as the OCM says in the application itself, they created this application such that a person could answer it without a service provider. But should you choose to retain a service provider, in particular an attorney, I do think that low to mid to high four figures is a good range for what you could expect here. I mean, if somebody comes in and tells you, give me $100,000 for filling out this first conditional adult use retail dispensary license, I would say run as fast as possible. That's insane. But for some of the later standard licenses that we're going to see, particularly the ones that are going to be more complicated, I'm thinking perhaps about the cultivation and even perhaps for the processing license, could even include the distribution license. But really for any of them, it's going to be a much more involved process for those later licenses. You are going to have to come up with the business plan, the sustainability plan, the standard operating procedures. You may hire a plan writer to work with you and your attorney to do this. But obviously, your attorney is going to be tremendously involved in that process. And there's just going to be a lot more work to do when it comes to those later licensing applications. So there, I do think spending more of your money with your attorney is going to be called for. Again, depending on which license it is and how much of the work you're able to do versus how much you really do need your attorney to do. You're definitely looking at a 5-figure expense at the minimum. It depends, again, which license, how much you're going to do, how much the attorney's going to do, how complicated, frankly, you want to make the whole thing as to where you're going to fall in that continuum. But again, the later licenses, I think your lawyer's fees are going to be significantly higher than they would be for this first initial conditional adult use retail dispensary license. So that's just to give you some rough idea of the attorney fees. When my clients hire me as a retained attorney, I don't really pitch them a flat fee or some type of fixed number for the application process. I encourage them to have me be their attorney for their cannabis business going forward. So that's going to be contracts and what changes in the law are there, what changes are there in the regulation, introductions to other service providers that I have in my Rolodex, be it accountants or real estate folks, or as we said earlier, plan writers, insurance people, eventually other people in the cannabis space that you may want to do business with. So if you're a processor, folks you might buy flower from. If you're going to be a retail dispensary, some distributors that you might be interested in having be on their route and delivering whatever cannabis products they distribute. So I just quote an hourly rate and, have a retainer and things of that nature, and just say, hey, I'm going to be your attorney forever. Here's kind of a guess of what we think some of the licensing is going to require. But frankly, you may end up spending more with me doing contract work and other regulatory and legal interpretation work going forward in the future than you might on the licensing. But again, every situation is going to be different. It's just, like I said, be careful. This first one, it should be, 4 figures at most. If somebody's telling you pay me $100,000 to do this first conditional adult use retail dispensary license, run as quickly as possible. All right, let's look at a few other questions that came in before. The next one is, when do you think the first fully legal recreational sale will be? And I do think the very first one will be at the very, very, very end of 2022. I am, I guess, cautiously optimistic that the Office of Cannabis Management and the Cannabis Control Board are going to meet their goal of having the first conditional adult use retail dispensary licensee in place and open in one of the DASNY spaces by the end of the year. They do need to get a move on that. The application is now open, so they will certainly be able to give out some licenses, possibly as soon as the month of October. But they do need to pick their design build partners all over the state. They need to pick some sites and either lease them or buy them, and then do the upfit for those dispensaries. I think the window is probably closing on that first sale being from a Manhattan or New York City area dispensary. For those of you that live in the New York City area, I mean, you can take months just pulling permits for a project, forget actually building it. So I do think if the state wants to make this happen, they're going to need to pick a space upstate. I think it's not terribly crazy to think they might pick a site in Albany, which will allow Governor Hochul to then very easily come to that site for a ribbon cutting ceremony. So I think that is more possible than opening a New York City area dispensary. But all of this, I think, is approaching a challenged timeline, right? So if they give out the license very quickly in October, go ahead and start picking some spaces upstate here in the next, several weeks. Get a design build partner and really crank the crank, especially if the site they're looking at is already a white box or, really ready for a design build partner to come in and just do the things that are specific to a cannabis dispensary. Look, it's we're 4 months from the end of the year. I do think it's possible in that time frame, but if not, I certainly think it will not be before too long in 2023 before the first recreational sale will happen. Again, it's going to depend on how quickly OCM and CCB can get through this licensing process. The application is open. They could start giving out licenses come October. But then the real challenge will be, are there any lawsuits related to the process that delay licensing or delay the stores open? And then can DASNY and the fund pick a few sites and get a design build partner and do that upfit very quickly as we move into the fall here? They're going to have to move very quickly. Everything is going to have to move very quickly, and things are going to have to go pretty much without a hitch. I do think it's still within the realm of possibility, like I said at the top, that happens this year. So like a store literally opens, between Christmas and New Year's, and they get the first sale then. If they keep delaying any of these things, or if things don't work swimmingly, as we say, as they move through the process, then I do think you won't be able to make it this year, and it will be 23. But I don't think it'll be too far into 23 before we'll see the first recreational sale happen here in the state. Next question: what non-cannabis related convictions will disqualify you from a CAT-ERD license? Is there a time frame for all of this? The time frame, I think, is the application closes 26th of September, and they're going to want to start issuing the licenses as quickly as they can after that after that application period closes. And I think they're going to want to move as quickly as they can to open the spaces and, build out the spaces and then open them. As far as disqualifying convictions, if you look at the cannabis law, it is generally not cannabis convictions that will disqualify you. And in fact, you have to have a cannabis conviction for this first license. So clearly, it's not only not disqualifying, it's a requirement. So that's a little bit different than what we're used to seeing as far as licensing applications in regulated industries. But there you go. When you look at the cannabis law specifically, there is a specific section which talks about what types of crimes and convictions might disqualify you from getting a cannabis license. It does seem that by and large, they are white-collar business and fraud problems. So like, did you cook the books in a business? Did you have inventory walk out the back door so you could pocket the money without paying sales taxes? Did you have any tax crimes or other business crimes of that nature? It definitely seems that if you had any crimes related to dealing with minors. So let's say you in fact, your cannabis conviction was selling cannabis to a minor, I do think that that might be disqualifying. I would encourage you and your attorney to look at this section in the cannabis law. It's just it very specifically talks about what types of convictions are going to be disqualifying, and the focus there really does seem to be financial and other white collar business crime. They want these businesses to be successful. They don't want you not paying your taxes. They don't want you committing fraud in the business. They don't want cannabis inventory walking out the back door. So it's going to be those kinds of crimes that they are most concerned about you not having on your record when it comes to the cannabis licensing. And again, this is all in MRTA. The Cannabis Control Board could, of course, add additional things if they wanted to, but I would encourage you just go look at that section in MRTA, and you will see what convictions they're going to consider as disqualifying for getting this license. All right. Let's go to a few questions from the backlog. And one of my favorites around the marketing regulations, which I have previously described as fairly draconian. Will there be restricted words or phrases in regards to business signs? Can I name my business, for example, Keith's Ganja Depot? And yes, there will be restricted words. If you look at the regulations, it seems fairly clear that the Office of Cannabis Management and Cannabis Control Board are going to want to restrict pretty much every one of our favorite cannabis terms from their marketing. So they use things like sticky buds and chronic as examples of words that you can't use. There are 5 specific examples in the regulation, but my read of the regulation indicates that it's not just those 5. It's pretty much any cannabis slang terms that you could use. And I do think ganja will probably qualify as that. So before you name your business Keith's Ganja Depot, I would encourage you to at least wait for the final version of the regulations to see if that version stays, where they're not going to allow you to really use any cannabis slang. Even after we see that final version of the regulation, I would encourage you to just email or call the Office of Cannabis Management. Very friendly folks there. In fact, I was working on a CAT-ERD application the other day with a client, and we had a question about the application while we were working on it. We literally called the Office of Cannabis Management and asked them that question in real time, and they answered it for us. So they were great, very responsive, and gave us the information we needed to complete that question on the application. So I would just call the folks at the OCM and say, hey, I saw that you've got the final regulations now about marketing and advertising. I saw that you guys are not going to allow, if it does indeed turn out to be the way it works out, that you guys are not going to allow a lot of the slang terms like chronic and sticky buds. Is ganja one of the terms that you're not going to allow? And I think they would be very happy to answer that question for you. But again, big picture, I do think the marketing and advertising regulations are particularly draconian, and I do hope that they are modifications to them before we see the final versions that they're going to have. So we will see what happens. All right. Let's see. Next question from in the session. When do you see the second round of applications rolling out? And again, this is the 9 standard applications that are called for in the cannabis law. And it's a matter of when are we going to see those? We've seen the conditional cultivation and the conditional processors. When are we going to see the 9 standard licenses? So it's entirely possible that they will roll out these applications piecemeal. It's entirely possible that they will roll them out 9 at a time. At the NECAN event that I was at this past weekend, very happy to see and frankly meet lots of folks that I've only known from LinkedIn at that event. We got to meet in person. But at that event, Tremaine Wright spoke. She was the opening remarks on the first day. And she said that They're going to race now, and we're going to have those regulations final before the end of the year, which means they need to release their draft proposal very quickly. Those regulations are going to have to go through the same regulatory review period. So it's however long it takes to get the proposed reg into the register, like, 3, 4, 5, 6, 7, 8 days, 60 days for public comments, then however long the CCB takes to figure out whether or not there will be any changes. And for the cat-erd license, they took 46 days to decide if there were going to be any changes. And then if they do make changes, it's another 45 days. So if we have to go through that whole regulatory review process for these standard licenses, I mean, you can say we're well into 3 or 4 months just dealing with the regulations. So if they want to get that done before the end of the year, they better release the regs like tomorrow, or the proposed regs tomorrow, or right after Labor Day. Even after Labor Day may not be enough time to do everything. So I do think the second round will roll out as quickly as the Office of Cannabis Management can get that first draft of proposed regulations out. I guess it's still possible that that could happen here by the end of the year, but I think it's increasingly unlikely. And I do think we're probably looking at first quarter of next year to get the second round of license regulations promulgated and get the application process started. But we will see how that goes and what's going to happen. All right, let's do another question from today's session. Are there any updates to the point system or algorithm that the state is using for the cat-erd licensing and the social equity licensing? So we know nothing about the social equity. Those regulations will be coming later. We do know that they're, in theory, going to be giving more points to the applicant if the applicant is the person that had the conviction rather than the person's parent or dependent or child. But we don't know how many more points. So if the convictee is applying, they get 10 points. And if the parent is applying, they get 9 points. Or is it if the convictee is applying, they get 10 points, and the parent is applying, they get 1 point? We just don't know anything about that. We know the kind of the metrics, this who is applying, did the qualifying business that the applicant have, was it a retail business? Did it look like a dispensary? So was it kind of like a bodega? Did they do retail? Did they have a store that people came into? Or were they completely online and all of their business was wholesaling, not retailing? We know the retailers and the people that came to a store will get more points. We just don't know how many more points. And unfortunately, I think there's a bit of a risk here. I would rather that Cannabis Control Board and the OCM had released the entire plan of how they were going to assess these applications and rank them. They absolutely opened themselves up to the risk of litigation by not disclosing how they're going to do this point system and assessment. So hopefully they're going to do that very smartly, and they're going to minimize any risk that they have. But unfortunately, right now, we don't know what the point system is going to be or how any of that is going to work. So not a lot of updates there other than what we already knew from the regulation itself. All right, I think we're going to do one more question from the backlog, and then we're going to call it for today. Will consumption lounges be allowed to sell alcohol as well? And the answer to that question is no. No, well, I should be clear. No licensed premise for cannabis is going to also be able to sell alcohol. So the premise where you're going to have a dispensary will not be able to sell alcohol, and the premise where you're going to have a consumption lounge will not be able to sell alcohol. It's not that the license holder can't have the same license. So a person that has an alcohol license can also get a cannabis license. They just won't be able to be in the same physical space. So a consumption lounge in that sense will not be able to sell alcohol because that'll be in the same physical space. It is a little confusing how they do this guidance in the cannabis law. They didn't really completely sync up the language between the dispensaries and the consumption lounges not being able to have alcohol. I think they could have made it a little more uniform and a little bit more consistent in how they referred to it. But the safe harbor, or I guess it's not really a safe harbor, the completion of this actually occurs in a different section of the law. So while the parts about on-site consumption are a little bit confusing and with dispensaries are not fully self-consistent on their language, they both kind of make it clear that you can't do alcohol in the same space. But there's another place in the alcohol law where, or I guess it's technically not in the alcohol law, it's in MRTA, and you get that the alcohol law is a subset of the things in MRTA that are specifically related to the cannabis and the things we're doing. Along with this law, there was a separate amendment to Section 102 of the Alcoholic Beverage Control Law, and it specifically says no alcoholic beverage retail licensee shall sell cannabis as defined in Section 3 of the Cannabis Law, nor have or possess a license to permit or sell cannabis on the same premises where alcoholic beverages are sold. So again, while they've kind of got some not fully consistent with itself language in the dispensary and on the on-site consumption part, further down in the law, they do specifically talk about if you've got a alcoholic beverage retail license, you cannot sell cannabis from the same premises that has a cannabis license. And so it just makes sense from that. Any place that could sell alcohol has to have an alcohol license. And if someone that has an alcohol license can't sell cannabis, it just follows on that anybody with a cannabis license can't be selling alcohol. This just all makes sense from the way the law is worded. All right, so I think that's it for today. I want to thank everyone for joining us on today's session. As I mentioned, we do these things every Wednesday at 4:20 p.m. New York City time. I encourage everybody to join next week and every week when we do this for our Ask Me Anything sessions. If you're not currently a connection of mine on LinkedIn, by all means, send me a connection request. I love connection requests on LinkedIn. We'll be happy to connect with you. And finally, as I tell everyone, no one is more excited about the fact that we're about to have a regulated cannabis industry here in New York. But frankly, the most important things coming out of the law are the justice issues, nobody getting arrested for cannabis, nobody getting convicted for cannabis, at least the low-level cannabis offenses here in New York anymore. We don't want any more of that. And we're working on expunging everybody's cannabis convictions in the state of New York. Those of you with the low level of convictions, those are getting done automatically. You still need to go get your certificate of disposition because everybody should have that. And for the higher level cannabis offenses, we're going to get 440s for everybody so that those convictions get removed as well. So that's what's most important. And everybody needs to do their part about that. From us lawyers that are going to be working on it to everyone in the cannabis industry that needs to be letting everybody know about these justice issues that got resolved in the law. So go forth and do that. And everybody have a great afternoon, and we'll see you next week. Goodbye, everybody.